There's no requirement to do a patentability search before filing for a patent. And in fact, any search that's done, any patentability search, will never with 100% confidence be able to give you everything, every piece of prior art that might be found during prosecution of the patent. It may be a cursory search using the patent database of the US, Europe might be worthwhile, but beyond that, the cost may not justify any results that you come up with. That is, the cost for a search might not justify. And keep in mind as well that the entire population of prior art can't be found because patents are not made public. And this is in the, I guess, the main patent offices. Patents filed are not made public until 18 months after date of filing. So the most effective prior art search could not find those patents. It's important to file early to protect rights and establish superior patent rights, to protect subject matter in an active area of interest where competitors might be working just as hard as your development teams to develop new concepts. The reason is that all patent offices in the world, except the US, work on a first-to-file basis. So if there's any dispute about who the rightful inventor of a concept is, should it happen that several parties file on the same concept, the patent owner will be, who is first to file, will be given superior rights in the invention. In the US, first to file, although there's some room for contesting who is first to file, who is the actual inventor, first to file is given the presumption of being the rightful inventor. And that's a very big barrier to overcome. So the way not to even get into a situation where you have to overcome that is to file early to protect your rights in the invention. It is true that a provisional application can be made more cost-effective or more cheaper than filing a regular application. The thing is that that's typically done at the expense of thorough specification and, most importantly, at the expense of crafting the claims that are needed for the regular utility application. So I would say that provisional filings should be limited only to cases in which a priority date absolutely needs to be reserved. Once the application has been filed, if you find competitors are copying the idea as embodied in the product they might be shipping, you do have certain patent pending rights, but, however, you can't sue them. So what are some options? The one main option that comes to mind is to analyze their products and consider a preliminary amendment, what's called a preliminary amendment, to your pending patent applications to amend the claims of the application to read more precisely on their product. Why does that help? Because once the patent issues, or even before the patent issues, if you wanted to go talk to that competitor to bring them to the table and get them maybe to take a license or some other arrangement, your patent application would be much more powerful in asserting those rights when it reads exactly on their products.